It's very easy to think of everything that's going on as lots of separate issues, but they're not. The centre of this is an underlying move away from the idea that a patient sees a doctor and that records are filled out and that those remain confidential. And this is happening for a variety of reasons and in a variety of ways. Now, most of you will have heard about online medical records by now. It's been in the press. There have been various things said about it over the last year. Yes, it gives people access to their own record, which is the way that this policy is being sold. But it is a very imperfect system. And at the moment, a lot of issues really haven't been addressed. They're being fudged over. There is a real problem with online records of coerced access, and you only have to think of victims of domestic violence who may have consulted their doctor about the domestic violence, and what chance do they stand of not having their record accessed. And then there is the problem, a problem I'm acutely aware of because I worked in young people's information, data protection, privacy rights for about 10 years. What about young people who are using services that they're perfectly competent to access without parental knowledge? How do they screen part of their medical record from their parents? And then what about managing transitions? There's the transition into adulthood. At what point do parents stop being able to access a record, and what parts of it can't they access? So you have a 12-year-old whose parent is fully able to access that record, there are no objections. Suddenly that 12-year-old is 14 and may have contracted a sexually transmitted infection, may be sniffing glue, and they go and see their doctor about it. How do you shield part of their record without arousing parental suspicions? And then there are other transitions into old age where people become less and less capable. How do you ensure that they keep their dignity and that somebody who is caring for them doesn't have access to a lot of information that actually that person would rather they didn't see? So it's those sorts of things. But actually, online records is not about online records. That is only part of the story, this idea of giving people access. It is about a wider joining up of records and allowing access. We'll have the next slide, Andrew. Strategy documents that have been behind this. If you think about, we've been hearing bits about joined up systems for a long time. It was a Labour policy as well. This is not a party political agenda, and certainly on my computer I've got research documents going back to the early 2000s about joining up health, social care, education systems, etc. But in May 2012, when the Power of Information came out, this was quite striking. Our NHS number will be used to connect our records across the whole system as we move between services. And so now we have the ability with online records for any practitioner working with you to access your records and to bring records together in a new way. And in fact, legislation is already going on. A lot of these changes are happening in little clauses in different acts at the moment that actually increase this power to join up information. If I could have the next slide. So we've got, for instance, at the moment, what is a draft bill, the Draft Care and Support Bill, that puts a duty to cooperate on a whole nexus of public services. So the local authority, any NHS body, hospital, GP, whatever, police, prisons, probation. And local authority also includes things like the housing department within the local authority, as well as various care and support functions. And then, unfortunately, something I hate to see, such person or a person of such description as regulations may specify, so that anyone can be added to the list as you go along. And clause 6 of the bill puts a duty on the LA to exercise its functions with a view to ensuring the integration of care and support provision with health provision and health-related provision. Keep that clause in mind as we go to the next slide, please. Children and Families Bill, currently before Parliament, just about to go into the Lords, if I remember correctly. Again, clause 25, a local authority must exercise its function with a view to ensuring the integration of special educational provision, this time, with healthcare provision and social care provision. And so we're increasingly seeing this ensuring the integration, which reflects the Health and Social Care Act, which placed duties on NHS bodies to ensure the integration of services and to ensure that the duty of cooperation on everybody. We're also seeing in the Children and Families Bill a rather interesting new concept, the Education, Health and Care Plan. We're moving away from the idea of special educational needs now quite quickly. And the idea is to bring people around a child who, to create a plan that incorporates their education, health and care, with it being envisaged that records will be shared in what's called a team around the child. This is something Sue and I are going to be talking about later in our workshop on the single care plan. Could I have the next slide? And finally, what the government has been saying is work will be done to develop secure linking of electronic health and care records wherever they are held. And these will follow individuals with their consent to any part of the NHS or care system. Well, let's talk about consent, shall we? Let's look at the next slide. I'm really rather tired of people saying, we need informed consent, we need informed consent. We need valid consent. And this becomes actually crucial when you're talking about young people or you're talking about people who may lack mental capacity. In order for consent to be valid in law, it must be informed, yes. It must be freely given, and the person giving that consent must have the capacity to do so. So please, whenever someone says informed consent to you, think three-legged stool. Informed, freely given, capacity are absolutely vital. If we could look at the next slide, informed consent we know about. I don't think I need to address that. This is about knowing exactly what it is you're consenting to, what will happen to your data, how it will be stored, what rights you have in relation to it. Now, freely given is something that I think Sue can probably talk a lot about as well. We've come across situations within local authorities, particularly, where they have used a personal profiling tool for children called the Common Assessment Framework for a long time, and this is now being extended to adults. And this is very much about getting professionals on board in a range of services. Where a child has multiple needs, you get all the professionals together and somebody carries out an assessment of that child's needs, and it covers everything about them. It's meant to be a consent-based process, but in fact what we've all come across who've worked in children's services is that children have actually been denied services if they refuse to cooperate with the CAF process. And it doesn't matter how much ministers have jumped up and down and said this shouldn't be happening, I can assure you it is happening. I did a study, the Nuffield very kindly funded me to do a study of the law relating to children's ability to consent to data sharing, which, if you're interested, you can find online on our website, because I brought it with me from Action on Rights for Children. And we FOI'd every single authority in the country to get their information sharing policies in relation to children and their consent policies. I can tell you there's only 3 passed muster as far as the law was concerned. The remainder varied from patchy to utterly disgraceful and completely unlawful. And these were the practices being used to secure consent for services, and people were being blatantly told they couldn't have services. So that's not freely given consent. We also found that a refusal of consent was considered as grounds for suspicion in itself. If parents said they didn't want their children's information shared with a social worker or with the school, it was assumed they had something to hide.
Not only do they have something to hide, but it's assumed then that they can use the risk criterion to share the information anyway.
Absolutely. So the grounds for suspicion is created, and then those grounds, that suspicion becomes a reason for overriding the lack of consent, and sometimes even instigating a Section 47 child at risk of harm investigation within the authority. So you might as well consent and have done with it. It's the way it seems. There's also a problem around consent, going back to this coercion, people being coerced into consenting when they don't want to consent, people being coerced into services they don't want. These are huge issues that need to be considered. And I think I'd better move on very quickly to capacity. Now, again, going back to young people, I would say before I do this, and I should have put it in, that it's worth looking at the Mental Capacity Act, which covers situations where adults may lack capacity to consent to medical treatment or their care needs. It can be a temporary situation where somebody's had a stroke, for instance, that's left them without speech and very confused. It can be where somebody has dementia and is gradually declining in health. It can be where somebody has sporadic mental health problems. But it is worth considering who would be, what powers that somebody would have to consent in place of the patient to sharing information and to allowing uploads of data or to objecting to it. The other thing is, again, around teenagers and around the journey into adulthood. The law recognises that young people have what we call evolving capacity. This concept is in the United Nations Convention on the Rights of the Child, Article 5, that we say that the passage from childhood to adult isn't an on-off switch, that children are developing all the way through their teens until a point where they are competent for themselves, and in any case at either 16 or 18 they will become competent. But until then, we have something called Gillick competence. This is after a very famous case, which Fleur remembers terribly well, where Victoria Gillick went to court to try and get a guarantee that her underage daughters would never be prescribed contraception without her knowledge. It went all the way to the House of Lords before she lost her case. And it was decided that a child can be competent to get contraception from her doctor so long as the doctor thinks it's in her best interest and she can't be persuaded to tell her parents, and she fully understands the risks of what she's doing. So that's Gillick competence. There was never any age dependency in it, and in fact all of the law lords, Lord Fraser and Lord Scarman, both stressed heavily that it could not be age dependent, because you cannot impose an artificial age on what is a steady evolution and that varies wildly from child to child. You can have a highly competent 11-year-old who can make very sensible decisions. You can have a really rather dippy 15-year-old who probably shouldn't be let out alone. And also children's competence varies in relation to the situation. And this is something we found from all of the lawyers we interviewed during the Nuffield study, that they were all absolutely agreed that you couldn't presume competence at any age, and that a child may be competent to consent to antibiotic treatment but would not be competent to consent to surgery. the child might be competent to consent to having information shared in one setting, but not in another. And so every single time a child is asked for consent, this all has to be assessed. And again, what we've seen and what I suspect is still going on in local authorities right across the systems is a presumption of competence from the age of 12.
Yeah.
And this actually has no basis in law whatsoever. Again, all of the lawyers, all of the professional bodies, even the Information Commissioner, who had given the advice that you might think about it, agreed there is no legal basis for saying a child from the age of 12 is competent to consent. So, it's going to be an interesting few months and years as this online records and this whole shared care record evolves to see how we cope with the people who are not, how bluntly can I put it, who aren't middle-aged, respectable men for whom there will be no problem in having access to their records. Let's think about women, children, and people who are in quite vulnerable positions, and then consider how far we want to go with online records and shared records.